So we'll kick off now, and if people do miss it, there is a live recording. There is a recording that was sent out to everybody later on. So welcome. My name is Jude McCurry. I am the CEO for SBRC on day 2 of my job. And this is the second webinar that we've ran this week, which feels like 10 weeks in time of COVID time. Everything is moving very, very fast, and then some things are not moving very fast, and we know people are frustrated with what's going on. But what we want to do from these seminars is give people the knowledge of what they don't know, and then they can start making informed decisions about what else you need to do to basically protect yourselves and your businesses and to be more resilient today. Today's seminar is around the legal implications of COVID, and we also have 2 members of Police Scotland. We have we have Ian Stevens and also Colin Coveney, because I think it's really important when we're talking about the legal aspects that we also have the connection with Police Scotland, so that people are not starting false rumours about what can happen or what you can be arrested with this, that and the other, that they are going to give a very practical guide as to the legal implications and what it means for you as a citizen and also as a business owner. Next week's session was also supposed to be around the financial, with banks and stuff, around the financial loans and stuff that were supposed to be available. We have delayed that for a while because we don't think the detail is ready. And the feedback from the banks is that they are still trying to work everything up as well. They've got the guidance from the government, but there's still a lot of detail to be formed on this. We're also in contact with SFE as well, with Graham Jones as well, who will keep in contact with us for any updates. The message I'm getting from the banks is probably from everybody: if people can be patient, the detail isn't there, and you are wasting your time sitting on a telephone line for an hour waiting to speak to somebody. Their call volumes for business banking has gone up from maybe 50 a day to 1,000 a day, so they're in the same position as every single organisation out there. It's a new way of doing business for them. They've got people at home with families and children running around the place and everything like that as well, but they are doing their utmost. And it's not fair to have some bank bashing and stuff like that as well. We're all in this together, and we will get the information out as soon as possible. So instead of sitting on a phone line to your bank, do something practical for that hour that will help you save your business and help you look after your staff, or even have, like we had yesterday, a virtual coffee morning just to check in on everybody. The next Tuesday, instead of what we'll do is we will get a group of VCs. So Paul Atkinson has been making some call arounds with everybody. And what we're going to do is have a session about what the VCs are doing for their companies, what the state of play is, and is there any other alternative funding and stuff that we can look at. Funding is still going on in Scotland. It doesn't have to be just calling your banks and stuff as well. So let's have a chat about that next Tuesday. So my message at the end of this is be resilient, but also be patient. Be patient with everybody. Be patient with your kids at home. Be patient with your colleagues and stuff. It's all a new way of doing things. And I think we're winning at this new world. So let's keep winning. What I want to do now is pass over to Paul Atkinson, and then I'll come back and I'll introduce the panels for the legal chat. Thank you.
Hi there, good morning. Thanks, Jude. For those of you who don't know me, I'm Paul Atkinson, the founder of Par Equity, which is an Edinburgh-based venture capital and angel network. We look after about 40 companies currently, all of which are going through their COVID planning and actions, reasonably well advanced on that. I also chair Taranata Group, which is a 150 FTE recruitment business. The brands being Head Resourcing, Head Medical, Change Recruitment Group and others. Again, our plans are reasonably advanced, but as Jude's already said, it's still a pretty evolving picture overall. I also chair Converse Challenge, which is the awards for the best university spin-outs, and Clark Communications, which have been helpfully supporting SBRC and Jude's team in terms of getting the message out to the press and so on. It's fair to say we're living in unprecedented times, with the business impact at this time being very severe and likely to get worse before it gets better. We will come through this on the other side, and there will be post-COVID business resumption. But in my view, things will likely change forever, particularly how folks view remote working, for example. No one really knows how long this will last, but my best guess is 4 to 6 months before the direct COVID impact starts to recede. But there may well be a second phase. Clearly, the antibody test that's been promoted and implemented shortly will be crucial in order to get the workforce and society back to normality as quickly as possible. This is the first time, possibly ever, that we have had something that affects all sectors all at the same time, as well as society as a whole, which is why we're seeing government support and extreme measures in the way we are. Most of my investment industry colleagues are expecting at least 12 months of direct financial impact, with all of them assessing how to respond in the short term, but also what a post-COVID world might look like. We're having, as Jude said, we're going to hopefully have a further seminar on that Tuesday next. It's fair to say most of my VC and angel colleagues in Scotland are still open for business, but obviously some of the sources of funding are a bit stressed at kind of this time. I mean, certainly from a PAR perspective, we're open for business. We're planning on this being a long haul, and we're all trying to operate as close to business as usual as possible whilst working within really tight financial constraints until we've got a better idea on the timing of things. My colleagues on this call will drill into a lot more detail regarding legal, regulatory and contractual measures to be considered, but it's also clear that every business is going to have its own set of challenges, with some sectors being far more affected than others. I commented on a webinar earlier in the week that perhaps product service market fit has changed, maybe forever. Some markets have disappeared completely in the short term. Remote working is now the new norm. Digital transformation has been accelerated as a result. I'm really pleased to report that most companies, most people, and most organisations seem to be adopting to the new working environment really well. And you know, a situation that wouldn't have been possible at all maybe 10 years ago. We will come out of this. I'm holding these calls to try and ensure that companies and people come through this in as good a shape as possible. We're all in this together, both from myself and both SPRC. We're here to help in whatever way we can. I'll now pass you on back to Jude just to introduce our colleagues, but hashtag here to help.
Thank you, Paul. And I just want to say thank you, especially to you, for all the support and stuff you've given to SPRC, early morning, late nights and stuff to pull this all together. And we hope that you all get some practical advice and help in the next hour or so. So first of all, I've got Gordon Downey from Shepherd and Wedderburn. Gordon, do you want to unmute, please? Thank you.
Okay. Thanks, Jude. I'll say just a couple of words for Shepherd and Wedderburn before I hand over to my two colleagues. We, like a number of other firms, we've also getting used to the new normal and working out new ways to collaborate with each other and with our clients. We've got our advisory group together, which details of which will be, I think, shown at the end of the webinar for people who want to find out more about our capabilities. But in broad terms, we've brought together legal specialists across a number of different fields to provide a sort of coordinated approach to helping clients on COVID-19 response across various sectors: food and drink, hospitality, infrastructure and construction, to name a few, where we're able to sort of share that knowledge and bring it together in a tailored way for our clients. My two colleagues are going to talk about two particular areas where we're getting a lot of concerns raised with us from our clients. Firstly, contractual relationships and how those are bearing up under the crisis. What happens in relation to those existing relationships when they can't be performed because of the virus. And Matt will speak about that. Kevin will then talk about another area which we thought would be useful for colleagues at the moment, which is regulation, both in terms of existing regulatory obligations that we all have to live under, the red tape, and how the red tape is actually being dealt with or adapted to take account of the crisis, and also and sadly it's necessary, but new regulation that's coming in or has just come in to deal with the crisis and how we cope with that as businesses, particularly around access to our businesses and the use of our business premises. So, Jude, I won't say any more than that, and I'll allow Matt perhaps to pick up.
Thanks, Gordon. I'm ambitiously going to try and share my screen so I can get some slides up here, so bear with me for a second. Hopefully that's working now. So one of the issues that we're coming up against time and time again at the moment is with clients who have existing contractual relationships, and because of the impact of Covid-19, they aren't able to perform the obligations that they'd agreed to. One of the trendy phrases that's coming up a lot at the moment is force majeure. And that's a clause in a contract which basically says that if there's any specified event that occurs, the parties are relieved from the obligations that they would ordinarily otherwise have under the contract. And basically it means that they aren't liable in damages for being unable to perform those obligations. I think one of the sort of initial points that I would make is that actually in the current circumstances, everyone is going through this and everyone is struggling in the same way. And so whilst there's obviously the legal issues that we're talking about today, communication is probably the most important thing in actually engaging with the counterparty that you're working with, really to try and understand the issues and look for alternative ways to work through this. But with that in mind, what I thought I'd do is I'd look at some of the sort of examples of typical force majeure clauses, because the second most important thing is always around the way that the clause is set up and the way it's defined, because there's quite broad and quite varied ways of dealing with this issue. So the first example on the slide is one that's basically your ideal in this current situation. So what you have is quite a wide-ranging clause that deals with a lot of specific situations, one of which is a pandemic. Very little argument that that covers this current COVID-19 crisis. Other examples that you need to think about, and this can include things that aren't necessarily directly from the pandemic, but other issues that have flown from that cause difficulties in performing your obligations. At the moment, obviously, we have basically a state of lockdown, and so wording around government order or other issues around that is also useful in terms of preventing your obligations under the contract. And then finally, you get some force majeure clauses that are very broadly defined, and it will usually have some general wording around beyond reasonable control. This is fine, but again, it does invite some grounds for challenge, and so it's about trying to understand at the very outset really the scope of the clause that you've got in your contract. Important also to note that you can't simply rely on things like force majeure. If it's not actually specified in the contract, then you're not able to deal with it. The way that it operates is generally to prevent people from performing. So if you can't perform your contract, then you are relieved from your liability. There's different wording again, and this is a common theme, which is it really does depend on the wording of the specific contract, because you'll see in the first example on the slide, prevented from performance. Now, the tenant's case that's on this slide there related to the First World War, and basically they were unable to get supplies from Germany as a result of the outbreak of the war. And it was quite a useful example of understanding what prevented or hindered means, because if your wording is around prevented from performing, then it's an incredibly high test, and what you're talking about is something that's not just difficult or unprofitable, but it needs to be actually legally or physically impossible to perform. Whereas if you've got wording like hindered in there, then that just means substantially more difficult. And so again, that's a useful thing to bear in mind when you're looking at the contracts. Some other things to think about, you can have different impacts as a result of force majeure. So one can be to suspend the liability that parties have. The starting point is basically everything gets paused for the duration of this event. And then it resumes again at the end of the force majeure event. So once things get back up and running after the COVID-19 outbreak, then you continue with the contract as normal. It avoids liability for the duration of the period where the event is taking place. A thing to think about as well that's quite important is just because you can rely on this clause, it doesn't mean that you don't have to take reasonable steps to try to mitigate that damage. And so what you need to do is think about what you should be doing as a counterparty to that contract in order to minimise the damage that's being caused to the other party. And then in some circumstances, the clause will also contain a provision around termination. And what that basically means is if this event continues for an extended period of time, for example, sometimes in contracts it'll say 3 or 6 months, it gives the other party a right to terminate the contract because basically nothing's happening under that contract anymore. So I thought it was also probably useful just quickly to run through some practical steps that you can take when you're looking at these clauses. We've obviously got the scope of the clause that I spoke about, and again, it's really important that it's all just around the wording of the clause itself, reading what it actually says and understanding carefully how your circumstances fit within that. But practically speaking, there's also issues to think about, and from my perspective, that's probably more important here rather than the strict legal issues. One of the things to think about is reviewing your business continuity planning and your disaster recovery policies. And that's obviously important for a massive range of reasons at the moment, but it's also relevant for things like mitigation to show that you've done what you can to manage your contractual relationships. It's also important to ensure that you're monitoring the situation, not just in the UK, but in all relevant locations, because quite a lot of the time you'll have suppliers or customers in different countries. And again, it's about thinking about what's going on in those jurisdictions as well, so that you can understand where the risks lie. Again, as I said at the outset, I think that a huge part of this is around considering other options. Everybody needs to be quite flexible at the moment. And so thinking about other supply options, whether it's possible to cancel or reduce orders or do other things that would allow you to continue with the contract as best you can without breaching your contractual obligations. That can be things like delivery schedules or agreeing variations to the contract that apply for the duration of the outbreak. And then having discussions with customers, it's also obviously important to provide them with reassurance. And I think that that's key here for two reasons. The first is really just on a human level, but secondly, you want to make sure that what you're doing is in line with your contract, and you want to be convincing them that you're able to continue to perform your contractual obligations so that they're able to work with you again going forward and work through this. I don't want to take up too much more time on that this morning. I know there's a lot to cover, so what I thought I'd do is just close it there, and then we can pick up any specific questions about that after we've gone through the other presenters. So what I'll maybe do is I'll hand over to Kevin. Kevin's going to look at some of the regulatory issues, and I'll pass over to him.
Thanks, Matt. I'm also ambitiously going to try and share the screen here, so hopefully that's successful. The purpose of this short section is really just to offer some observations around the changing legal and regulatory landscape following the government's decision to close down all non-essential premises, and also to offer some suggestions regarding the regulatory implications it will have for those sectors that do continue to trade. See if we can move the slide along, which doesn't seem to be doing what it should be doing. There we go. To put the week in context, which has been an especially fast-moving week, I've put up some dates in the slide. The Scottish Government has issued its guidance. The Coronavirus Act 2020 has come into force. The Scottish ministers yesterday made a declaration that there's a serious and imminent threat to public health, and as of last night, many aspects of the Coronavirus Act 2020 have had force of law as a consequence of the 2020 regulations. Whilst the guidance was not legally binding, the new regulations give the requirement to close businesses and premises force of law. We don't really have enough time today to interrogate the finer details of the guidance or the Act or the regulations, but it's fair to say that over the course of this week, we've seen issues arise in two particular circumstances or two particular areas which demonstrate the regulatory challenges ahead. Firstly, there'll be a considerable impact on the licensed and hospitality trade in Scotland and how they continue to trade within the law. And then secondly, there's also compliance with health and safety law. That's an issue that applies to all employers, excuse me, but we're seeing that come into very sharp focus in the construction and energy sectors, where there are starting to become diverging opinions. In Scotland, the initial reference point should be the Scottish Government guidance, and as of last night, Regulation 3 of that guidance. The First Minister and the Government has been clear, these are rules to be followed, they're not advice, and that has led to the closure of all retailers that sell non-essential goods. Regulation 3 makes reference to Part 1 of Schedule 1, and that means that all bars and nightclubs close without exception. Pubs, restaurants and cafes must close, but of particular relevance to retailers in the food and drink sector, food delivery services and takeaways can remain operational. And a number of retailers also continue to operate, and that is good for business continuity and for the economy. For those retailers that choose to continue to trade, attention is quickly turning to the possibility of diversifying into home deliveries of food and/or alcohol. That is not without risk. Questions arise as to ensuring compliance with the Licensing Scotland Act and what is likely to happen with licensing boards on the enforcement side of things. And some key issues that we've seen in discussions with clients and with licensing boards this week are on the slide. It is worth noting that there's been no consistent approach by licensing boards to deal with new applications. And licensing boards, like any regulator or like any business, frankly, at the moment, is having to deal with things on the hoof. They're running on skeleton staff and things are taking longer to process. But for retailers such as restaurants, news agents and other licensed premises, what does this actually mean? In essence, businesses can continue through some sort of system like click and collect or similar, but social distancing considerations must still apply, or drivers could deliver the goods to a customer's home. The key point to take from this is that licensing boards have already indicated to us that restaurants and cafes will be able to offer home deliveries for food, even if this is not explicitly mentioned in their license. That's a real boost for business continuity and a good example of both business agility and also, on the other hand, from the licensing boards, what you might term regulatory forbearance in the circumstances. The new regulations, as of yesterday, for any premises that continue to trade, also insist that where customers enter the premises, a distance of 2 meters should be maintained. Customers should be admitted in sufficiently small numbers, and that 2 meter distance is also maintained for people waiting to enter the premises. I have to say, from what I've seen over the last week, many businesses have already been implementing them, but the regulations now give that force of law. Police will have the power to enforce the directions, and the law will provide for criminal sanctions and fines for businesses breaching those rules. The government has not shut down all business, but it's important now more than ever to know the regulations you're working within and remain up to date as the law develops. And then the second issue where businesses do continue to operate, managing risk and health and safety is at the heart of the national effort to deal with coronavirus. For many years, the Health and Safety Executive has been advocating, advising and supporting businesses to adopt good risk management practices. The Scottish Government guidance poses 3 questions, and I've put those 3 questions on the slide. But issues still require to be ironed out. So, for example, for those in the construction sector, the picture has been a confusing one. In Scotland, under the guidance, the First Minister had all but banned the majority of construction work. Yet, in last night's regulations, there is no mention of energy and construction sites. In England and Wales, a more relaxed attitude so far prevails. But if construction work is to stop, it seems to me key questions would include, will there be serious safety consequences if the project is left unfinished? Will downing tools at this moment in time mean the construction site is then inherently unsafe? And is the construction project critical to the national COVID effort? Depending on how matters develop, we might see a divergence between the rules in Scotland and in England and Wales, and that is unhelpful. There are also stories of retail premises being accused of prioritising sales over health and safety. There are claims that employers are failing to provide staff with adequate guidance on how to stay safe at work. There are insufficient cleaning and hygiene products being provided, and there is poor communication from head office. These are not COVID-19 issues, these are obvious health and safety issues where the business has failed to introduce and implement proper risk assessments as the pandemic develops. Enforcement in health and safety context is not new. HSE inspectors already have powers to enter premises, to in-gather evidence and to interview employees. If concerns are sufficiently grave, prohibition and improvement notices can be issued. But the 2020 Act and the regulations will bolster those powers by allowing the Scottish ministers to direct that specific premises are closed down. The guidance reinforces an underlying point under the current regime. In circumstances where business does continue, employers must not lose sight of the fact that there are already laws regulating health and safety. Coronavirus has not changed that. Employers and their contractors have duties to secure the safety of their employees, and allowing employees to work in an unsafe manner could give rise to criminal and civil consequences, which could be significant if you get it wrong. And some of these duties, which I've mentioned on the slide, come into even sharper focus during the pandemic. So, for example, what are your emergency response arrangements? What are the supervision arrangements? If senior management are self-isolating, who takes over? Is there a plan B? Many of the social distancing measures I've mentioned now have force of law in relation to 2 metre distances. But perhaps very relevantly in the current time, for employers, managing home workers is just as important as managing any other employee. When someone is working from home permanently or temporarily, as I am at the moment, an employer should be thinking about, how do I keep in touch with them? What work are they doing, and is it safe? Have I conducted workspace risk assessments? Likewise, I don't want to take up too much more time with that. It's a bit of a whistle-stop tour through some of the regulatory issues, but plainly coronavirus is challenging to businesses if they do continue, and it's important that there's ongoing vigilance in relation to both the regulatory requirements as they change and that health and safety obligations are being complied with. So I'll then hand back perhaps to Jude to move on to the other presenters.
Okay, and next we've got Andrew Lay from Adelshaw Goodard.
Thanks, Jude, and good morning, everybody. As has already been said, this is a huge period of rapid change for all of us. We as a firm have 11 offices around the world, with 3 in England and 3 in Scotland. And last Monday, we had 2,000 people suddenly working from home with only 1,200 VPN switches. By Friday, we had 2,000 VPN switches, and the pace at which our IT team has adapted has been staggering. We're also quickly evolving our use of platforms like Zoom, as we are this morning. So I think where there's a will, there's a way. And as a nation, if not a planet, we're already in a deep recession. There was a good article by Douglas Fraser in the BBC Business News yesterday about that. I think the big difference to the last recession prompted by the credit crunch is the context of this one and the resulting willingness of people to collaborate and help each other. This involves government, but it's a mistake to be overly reliant on government initiatives. Like the NHS, they have a limited bandwidth and will naturally focus on the priority cases. So we therefore need to think as broadly as possible about how we can collaborate. One example I've got is in the area of people redeployment. So it emerged very quickly last week that we had a number of clients who were rapidly shedding staff, particularly in the hospitality and retail sectors, whilst a number of clients in food production or major grocery were crying out for people. And so we've been spending a lot of time in the last 10 days trying to effectively match those companies with each other, put in place a master secondment agreement, and then allow them to share staff. There are HR issues with that, there's health and safety issues with that, but it still comes back to where there's a will, there's a way. We have created a site, the link to which will be put up at the end of this session, which is our one-stop shop. We keep it maintained, so please do visit that. Please do hopefully find the content useful, and if you have any questions about the things you see, then do feel free to contact any of us. I'm going to hand over to my colleague Gaynor. I'll just quickly mention who's following me. So Gaynor is going to talk about government loan schemes. Jamie McIntosh is going to give you a very brief overview to keep you on the right sides of solvency laws. Alison Newton's going to give you a brief perspective from real estate, and David Hughes is going to talk to you about employment matters. Over to Gaynor.
Thanks, Andy. So I'm going to talk about the practical application of CBILS, which is the Emergency Funding Scheme for Small and Medium-Sized Businesses. I'm going to focus on the practical application, firstly because You can access the rules through the web page that Andy mentioned, and also through the web page that Gordon mentioned earlier on in this session. And the rules themselves are quite opaque, they're quite high level. So what is really important is how the banks are interpreting these rules and how they're actually rolling out both the CBILS funding and their general business as usual funding during this period. Because there does seem to be a significant mismatch between the expectations of businesses considering the schemes as an option and the lender's ability to deliver. So what I'm going to do in the next sort of 4 minutes is just share with you some of my thoughts based on what I've gleaned from talking to RMs, from talking to businesses who are trying to access the scheme, questions that businesses have had about the scheme, and also from talking to a couple of my colleagues who are working directly with the banks on their interpretation of the scheme. Now, CBILS is not appropriate for every business. If your business is suffering or has suffered financially prior to the COVID-19 crisis, CBILS is not for you. It is not a source of funding that can be used to replace more expensive funding and allow cash flows to be released. And also, if businesses have access to cash flow from elsewhere, for example, private equity-backed businesses, it's unlikely that CBILS will be for them. Now, because the banks, and I think Jude had mentioned this earlier, the banks have been absolutely inundated with requests from customers, not just about CBILS, but generally about payment holidays, capital, repayment, stretch outs, interest-free periods. And so therefore, they're having to put in place triaging processes. Now, these triaging processes are designed to ascertain which customers require critical care. So which customers not only have liquidity problems, they have those liquidity problems now. And so certain businesses are being asked to wait. Those are the businesses that banks assess as having cash that is sufficient to tide them over in the short term. So if you contact your bank and you're asked to wait, don't see this as a sign of a discouragement. This is simply born out of a completely unprecedented demand for their services. So what is really important for any request, whether it's a request for business as usual funding or whether it's a request for CBILS, is that you provide your bank with sufficient information to allow it to positively message your request internally and also to move it quickly through the credit process. So every bank should have a list that they will be able to provide you with, which will tell you exactly what information they will need to process any requests through their credit processes. So you should, as a first step, ask your contact at your bank or your relationship manager for this list. And then you should embark on the job of actually gathering this information together. Now, every bank will have a different list, but generally what you'll be asked for is you'll be asked for an assessment of your current financial position. You'll be asked for a comparison of that financial position to where you were 2 months ago and to where you normally would be at this stage in your cycle. You'll be asked for key indicators like lost orders, current business orders. Matt had mentioned practical steps around cost mitigation. That's really important. It's really important that is demonstrated and that is information about that is delivered to your bank. Most importantly, what you'll be asked for are your financial projections. Now, I appreciate that those are extraordinarily difficult at this current time, but they're also extraordinarily fundamental to a bank in assessing your suitability for funding or for CBILS funding, because ultimately, whatever funding you require, it is funding and it will need to be paid back. So your financial projections should demonstrate that, once this crisis starts to ease off, and once your business starts to retick, you will over time be able to pay this funding back. And also, what I think from speaking to a lot of bankers is really important is if anyone within your business has got any director within your business has got experience of helping companies through distress periods, I think it's really important to articulate that to your bank because it will be really relevant to them in assessing application. So I think probably one of the most fundamental things to note is that CBILS is only available and the rules only allow lenders to access the CBILS scheme if they are not able to lend to your business on their normal commercial terms. So therefore, when they start to assess a business, they have to assess it with that in mind. And so therefore they'll look at your existing security package, they'll look at your assets, they'll ascertain whether there are any other assets that they can take security over, which would enable them to lend to you on normal commercial terms. And CBILS is only available if either that isn't possible at all, or that is not possible to provide the full amount of funding that is requested. So as Jude said, this is a new scheme. It's changing every single day. Banks are just trying to get their head around it. Full details of the scheme, what they were, and as I said, they are very, very, very bare bones. We're only released to RMs on Monday, and they are all working from home, and they've got the challenges that we're all facing. So they're desperately trying to grapple and get their heads around how to interpret these rules. And so therefore the bank's interpretation, the bank's approach to the rules is genuinely changing almost on a daily basis. But the need to apply normal commercial practices first and before any dipping into the CBILS scheme occurs is leading to anecdotal stories that are coming out of businesses approaching their lenders for CBILS, expecting to get access to the scheme and access to the scheme quickly, and finding that what they're getting in return is an offer from a bank for an overdraft or for a term loan at a particular margin, or they're being asked for more security. And most controversially, some banks are asking for personal guarantees. Now, the reason why the banks are asking for these personal guarantees, I think, having spoken to people who are sort of directly advising the banks on their interpretation of these schemes, is because the banks think that they have to apply their normal commercial processes, and if their normal commercial processes require personal guarantees, then they're interpreting that as saying that they have to ask for personal guarantees if that is part of their normal commercial processes. That said, the BBA have expressed a very, very negative view on this. We've all seen the reports in the press, and my feeling is that because of PR reasons and potentially disastrous PR impact of lenders asking for personal guarantees, I imagine that over time, and as this process all beds in, those requests will start to fade away. Now, one question that we have been asked quite often is, what's the best bank to ask for CBILS or access to CBILS from? And the candid answer to that is, this is not a time, I think, for forum shopping. I think the best option is to contact the bank that has been with you, prior to this period, that knows you, that knows your financials, that knows your management. They're the bank that is best placed for you to speak to initially on this. Because each of the banks and each of the lenders involved in the scheme all have to apply the same rules. They're all applying the same criteria. So I don't think that this is the right time to be forum shopping. And the point that I'd like to end on is the fact that whether you're accessing CBILS financing or whether you're simply getting business as usual financing, it is financing, it is funding, it needs to be paid back. And so therefore, when any business is considering taking on this funding, you have to have a consideration of issues like directors' duties, whether it is sensible and whether it's in line with your duty as a director to be taking on funding at this particular point. And hopefully that's quite a neat segue into what my colleague Jamie McIntosh is going to say. So thank you.
Thanks, Gaynor. My name is Jamie McIntosh. I head up the restructuring and insolvency practice at Addleshaw Goddard in Scotland. Hopefully you can all see me and hear me properly. I'm just going to quickly cover off duties directors have when companies are entering into financial distress. There's been a relaxation of rules in Germany and Spain, but not in the UK yet. That may come, but it's not at the moment. So normally directors have duties to act in the best interests of their shareholders and the company. On an insolvency, that duty from the shareholders to be in the best interests of the company's creditors. The duty changes when no reasonable director would believe that there is no reasonable prospect of avoiding insolvent liquidation. The reason this is important is that if a director trades on through that period and does not act in the best interests of the creditors, then he can potentially be personally liable for wrongful trading. I recommend 4 practical steps to minimise risks for directors. The first is to instruct a full business review That helps manage cash flows, allows you to concentrate on profitable parts of the business, and possibly even gives you an opportunity to reshape the business. Even in the time when we're all social distancing, I really would encourage people to hold frequent board meetings. In the majority of cases, these can be done over the phone. It makes sense to carry these out, and it makes sure that all the directors are fully aware of the current position of the company. You can get a consensus, which helps show that you're acting reasonably, and also you can distribute responsibility, not just amongst the directors, but also further down, so you're sharing the load amongst the others in the company. You should keep key creditors informed. Keeping key creditors informed allows you to manage expectations and potentially gives the company extra time. You obviously need to balance that with the possible risk of information being leaked out and the potential negative impact on the business. So there's a commercial decision to be made there. The fourth and final piece of advice I'd give is seek professional advice. Speak to lawyers, accountants, or other professional advisors. Courts are very sympathetic to directors who act reasonably, honestly, and sensibly. And if nothing else, speaking to a professional advisor helps share the pain. And as many people have said today, we're all in this together. That's a really important message. And by sharing that and doing that, it helps everybody get through this together in this difficult period. So that's all I'm going to say. I'll now hand you over to Alison Newton, who will give you the real estate side of things.
So I'm going to, just in case we run out of time, I'm going to donate my slot at the moment to David Hughes, because he's going to speak about employees and furloughing, and I think that's probably incredibly important for this audience. So I'll unmute again.
That's very kind of you, Alison. Thank you very much. My name is David Hughes. I'm a partner in the employment law team at Addleshaw Goddard. I've been specialising in employment law for the best part of 20 years, and I think it's fair to say, even having been through the economic crisis in 2008, I was working in Aberdeen when we had the oil and gas crisis a few years ago. We've never had to deal with something like this, and it is presenting us with some particular challenges, which everyone in our team is rising to meet, I have to say, very admirably. Employers are coping as well, and at this stage, I'm going to have to mention the F word. It is obviously what you're all here to hear about, at least from the employment law context. And furlough seems to be the only show in town as far as employment law is concerned, at least for the course of the last few days. And I think it will be for a short while to come yet. There is a lot of guidance which is available now online, and late last night HMRC thought it would be a nice trick to play on employment lawyers to issue further detailed guidance. So we all had a late night last night looking at this. And what I want to do is just to run through some of the basics on furlough. Some of this you will know already, but I want to cover as much as we quickly can in the short while that's available just now. And then we'll see where we get to after that. So first thing is, who can claim? Well, any UK business, any UK employers, they have to have a UK bank account and they have to have a payroll, UK payroll as at 28th February 2020. They can claim in relation to any of their employees, and it doesn't matter whether they're full-time, part-time, zero-hour contracts, flexible workers, etc. In relation to employees who have already been made redundant, as long as they were made redundant following 28th February 2020, and if they're rehired by their employer, then it will be possible to place them on furlough as well. Now, I would recommend before you do that you do take specialist legal advice, because it's not straightforward to rescind a notice of redundancy, and there may still be an entitlement for these employees to redundancy payments. As far as what employees can do or can't do during furlough, the golden rule is that they cannot work for the employer during furlough. They can do voluntary work, they may be able to do some training, but they can't do work and they can't do anything that will provide services or generate revenue for the employer. Payments that are made under the scheme are taxable. It was helpful to have that clarification last night. Employees who are working reduced hours or for reduced pay are not eligible for furlough because they're working. And again, the golden rule is that if you're working, you cannot get furlough. In terms of how you actually place employees on furlough, it will be very rare indeed for the employer to have a right under the contract of employment to furlough an employee. The rules are subject to normal employment law, so almost always you will require to get the employee's agreement, and that has to be in writing. It can be signified in lots of different ways, and I know that we're using electronic signatures and so on just now quite commonly, but you do have to have a specific express agreement from the employee, and it does need to be quite detailed. Employers don't have to place all employees on furlough at the same time. You are entitled to select parts of the workforce or individuals within groups, but you do have to be careful when you're selecting for furlough. You can't select on the basis of anything that would be unlawfully discriminatory or contrary to the Equality Act. Once employees are on furlough, you have to keep them on a period of furlough for at least 3 weeks at a time. It will be possible to rotate employees in and out of furlough, but only if you do it on these 3 weekly cycles at least. And if somebody's on furlough for a shorter period than 3 weeks, then they won't qualify for government support. Once an employee is on furlough, it does seem that it will be possible to still serve notice of redundancy. That was clarification we got yesterday, and we're still trying to work out whether the furlough grant would be available during the notice period. I think it probably would, but then also whether the employer would have to pay normal wages during the notice period. So even if you don't have a normal agreement to make up the furlough pay to normal rates, you may need to during a period of notice. Claims in relation to the furlough scheme can be backdated, and they can be backdated as far back as the 1st of March or to the date that the employee stopped working, whichever is the later. And you cannot backdate to a period where the employee was still working. During furlough leave, employees otherwise have normal employment rights. Employment law isn't being suspended during this period. It's very important that employers do make sure that they continue to comply with all employment law regulations and obligations and the contract of employment, except insofar as it's been varied by your furlough agreement. Employees on unpaid leave cannot be furloughed unless they were placed on unpaid leave after the 28th of February 2020. Employees who are on statutory sick pay, it's been clarified they cannot be furloughed until statutory sick pay has ceased. But if somebody is off under the shielding arrangements, and you can get details of that from government websites, then they can be furloughed. And then finally, there will be employees who are on maternity leave and other types of leave. Deal with them as normal under the statutory schemes that apply. As far as working out what the 80% is when you're dealing with the calculation of the HMRC and government contribution, for salaried employees that's pretty straightforward. It's simply what they were getting paid as of the 28th of February. For those whose pay varies, then you'll be looking at taking an average of either what happened over the last 12 months, or you can look at the same period last year and see what was paid to the employee at that point. And whichever is more favourable, you're allowed to opt for. And then if somebody hasn't been with you for a full year, then you just have to take an average over the period that they have actually worked for you. So there is an awful lot in all of this. What I would say is don't panic. It is quite complex. It's much more complex than it at first sight seems. But with a good agreement in place, there's no reason at all why this isn't a scheme that will work extremely well for employers. Final point to make is, of course, it's just been extended also, a similar scheme extended also to self-employed workers as well, which is, I'm sure, a great relief for many.
Right, I'll then pick up again on the real estate point. Jude, I think, are you extending?
Yeah, I was going to come on to say to extend it. I've just let all the panelists know nobody has dropped off, so that's quite good. So yeah, you continue. I think it's really valuable that we get as much information out there today as possible. I think people will have got a lot of information so far, so on you go.
Okay, thank you. My name's Alison Newton. I'm going to talk about real estate. I'm going to home in on leases and occupancy and also something around transactions. Gaynor talked about bandwidth, governmental and regulatory bandwidth, and I think that's exactly what's happening in Scotland. In Scotland, the typical quarter day was 28th February, so before this really blew up, and the next one is not till 28th of May. And that is why the Scottish Government has not made any legislation or regulation, or even looks like it's on the agenda, to match the same comment that's been made in England and Wales, i.e. that failure to pay the quarterly rent on the English date of 25th March would not entitle a landlord to forfeit the lease. Let me put that more simply, is that was permission to not pay the current quarter's rent. That's how people heard it. In actual fact, what it really meant was it was a deferral of rent. It wasn't a wiping out of the slate. The word that is used in England is forfeiture. The equivalent in Scotland is a quaint word, irritancy. But what that is the landlord's right to terminate a lease. Something may come in Scotland. It's not in the emergency category. I don't think we're seeing it imminently. And so what that means is, what is the arrangement that tenants and landlords should come to? Your view will change, I would imagine, dramatically, depending whether you are a landlord or a tenant. To echo what Jamie McIntosh said about directors keeping track of their business and staying in touch with their creditors, a landlord is another sort of creditor. Speak to your landlords. They also probably have funders to deal with as well. Ask if you can go immediately to monthly payments, or see if there's another negotiation that can be done. So, for example, there will be businesses out there who know there is a business for them when it all starts to pick up again. There are deals that can be done with landlords. They're called re-gear deals, and that might mean a rent-free just now, but a longer lease and a higher rent later. You won't know until you speak to them. For the people who are really hugely concerned about their business just now, then it's about the financing just now and speaking to the landlord, because the landlord will need to back with any bank that's lent money to the landlord over the value of the property. So communication. Sorry to be so basic about it. Any of the holidays, rent holidays that have been given in England are about rent only. You would think that if you're in a building or an estate where there are common charges or estates charges or service charges, that these might go down because there's just not as many services being provided. Again, speak to your landlord or speak to your managing agent and see which of those could be turned off immediately. It may not be the case if deep cleans are happening or increased security, and I suspect Ian or Colin will want to make a comment about security inspections of premises. You may not, but at least you and the landlord are in contact about that. I've used the word rent-free, I've used the word rent holiday, I've used the words rent deferral. They're all quite different. If you're agreeing something with your landlord or your tenant, you need to be really, really clear what you mean. Is that money going to be backed up and paid again later, or is it the slate being wiped clean? And I would actually use those words to make sure that you both have exactly the same understanding. Lawyers or not lawyers can put them in place, but that is that level of understanding that you need. I want to mention one other thing. You may have seen in the press that the land register has closed, and that's correct. It has completely closed until they work out how they can deal in Scotland with taking on registrations that don't involve the delivery of physical documents. So there are really high-level conversations taking place between insurers, the Law Society, the government, the registers, to work out what can be done. There is probably one category of items that can be dealt with, and these are exceptional emergency transactions. So there were people, can you imagine, who were in the middle of moving house just now? So family homelessness would be one. The registers will look at doing something if your lawyer makes a case for you of exceptional hardship. I also believe that another emergency transaction might be if you are a developer or house builder, you have a year end, you have a liquidity crisis, you have a cash flow need, and that this is something that is going to help you. Getting the money in for a sale is something that's going to help you maintain your workforce, keep the doors open. Again, you need your lawyer to make that case to the registers. I don't think that any of us think the registers are going to open soon, because we talked earlier about the tooling up that's been needed with IT, and they are really working to try and work out what an online solution might be for registration of land. So if you've got something on your horizon, I don't know, for the next 12 weeks, frankly, I think you need to be speaking to the other side and to the lawyers about what you can organise if this is about cash flow. I alluded there to visiting your property to check security, and I'm certain that either Colin or Ian will want to make a comment on that. Jude, and that's all from me just now.
Yes, so for people who have missed the beginning of the call, we also have to get his title right, Chief Inspector Colin Coveney and Inspector Ian Stephen. So we had some discussions with some of our clients, particularly garage owners and having cars and very, very expensive cars on forecourts and stuff, as to how they will protect their business around COVID. So I want to hand over to Colin, because yesterday the police have issued a statement around employees visiting premises. Colin, do you want to unmute?
That should be it. Okay. Thanks, Jude. I hope everybody can hear me. Yes, in relation to what we've been discussing this morning, it's all very interesting, and it's good to see that the police are facing exactly the same challenges as everyone else, and as numerous people have mentioned, we're all in this together. I think that's the bottom line. There are powers coming to us. The Chief has been very clear that in the use of the powers, he hopes that to be sparingly. It's only for enforcement of government guidelines if we have to. The bottom line is it's going to be about communication and about sharing some of the pain and difficulties ahead. But in relation to the specific question about checking and security, the Home Office issued guidance yesterday, which was essentially about providing a bit of comfort to corporate operations and businesses to say that it is in order to be checking forecourts, to be checking businesses and premises. The bottom line is it's about trying to make sure that law and order's preserved, and it's about reducing demands on policing as well to allow us to focus on other aspects. So that is the most important bit. It is absolutely an allowable action. What I would be keen to make sure is that all providers, though, are following the wider government guidance. It's not about specific powers, it's about making sure we keep everybody safe. Hopefully that provides a bit of clarity, Jude. The bottom line is, yes, it should be provided and continued.
So we had a discussion as well that basically what probably you should do as a business owner is provide letters to those staff owners to say that that's what they are going to do, because what we don't want is what we can see around the marketplace is a lot of urban myths around COVID, and people then, if the police stopped anybody in a car, they could say we're going out to check a premises, and we don't want to add a lot of admin onto the police and stuff. So you can do an official letter from either directors or managers to say, and maybe with their number and email address and stuff like that as well, and the police then can take a photocopy, or not a photocopy, a photograph of the letter. So it's common sense, it's about not causing hysteria, and it's about also engaging with your insurance companies as well, because we haven't touched on that a lot of your insurance contracts will not be able to be, leaving premises empty and stuff like that. You are responsible for all that kind of stuff as well. So maybe we look for an insurance person next week to come in and do some sort of session as well. Do you have anything else, Colin, around the legal aspects? Is there anything else that you think is going to come down the line? And I know I'm not asking you for, your hearsay or anything like that, but is there anything else that you think, after listening to the panel, that the police should get the message out there?
No, I think, like I said earlier on, Jude, the bottom line is we're all in this, we're all at the same state as everyone else. We've been through massive corporate restructure and strategic planning for coping with coronavirus, and the powers that various acts come. I don't think we're indifferent to any of the other delegates today in terms of how we respond to things. I think what is going to be important coming forward from our end is that the people can expect the police to be there. They can expect us to provide a service. They can expect some engagement, and it will not be about the waggy finger, I would hope. It will be more about trying to educate and keep people on the right track. It's not going to be about stop checks and people being removed from vehicles and the likes, but I get your point in terms of it would be really useful if employees are out carrying out critical functions, that they have got that bit of comfort behind them from the director level that would provide them that bit of reassurance. the police will be well aware of that, and I would expect some common sense to be applied. And that's very much the Chief's request to us, is it's about making sure that common sense approach is taken by all the officers. So, no, I think the critical thing is it's about communication. I would expect a lot of comments to be coming from ourselves and government over the next while about the regulations and about the law and legal aspects, but bottom line is we're in this together. We need to try and work our way through it and come out the other side.
Yeah, thank you very much. So we've had a really good session, I think, and I found it really, really useful, and it was factual, and any of the stuff that was going out, I think we now have facts to make informed decisions in our businesses. I want to hand over to some of the Q&A. So David had picked off some questions there that he wants to cover, and I'll let him kick it off. There's so many different comments coming in, so to me directly and also on the panel. So I'll kick it over hand it over to David to kick off the first of the Q&As.
Thanks. Yeah, so the first question that I'd noticed, actually I tried to cover when I was doing my talk, so hopefully I did, which was how you deal with people who don't have normal salaries. And you can take averages, and that's usually going to be the thing to do, but you can also look at the same period last year if the person was employed then, and you'll be able to work that out at the same time. Somebody had also asked if we have a form of words to put into a contract in order to satisfy the requirements to change status of an employee to furloughed. And I think you have to be very careful with that, because you probably don't have the right simply to change the contract. You will almost certainly require to enter into a period of consultation with employees who are to be affected and to have them agree to the changes that you're going to make. Now, whether employees agree or not remains to be seen. I think in many cases they will, because they will recognise the alternative as redundancy. There may be some employees who are perhaps getting towards the end of their working life, or who may benefit from very generous enhanced redundancy schemes, who will seek to take advantage of that and will say, actually, don't furlough me. I'd be perfectly happy if you put me onto redundancy, and I'll be happy to take the package. So you may get that as an issue with some, but generally speaking, I think employees will be understanding of why businesses are going through this. The other point, of course, is that employers aren't required to make up the difference in employees' wages, and it may be that many employers won't be able to pay any more than the government grants that they're going to get. But in those cases, employees, again, may have difficulty, particularly higher earners, may have difficulty having their monthly income capped at £2,500. So we'll just have to see how that all works. But if employers are able to make up the difference in wages, then there seems to be very little disincentive to employees to accept the furlough arrangement. Hand back to Jude.
Got to unmute myself. Another question for you: if furloughed, can employees work on a temporary contract elsewhere? Or also, the discussion we've been having as a group is, if people are furloughed with specific skills, could they then come along and work, hopefully with the SBRC, and help us out, or charities, or basically volunteer themselves for the NHS and stuff like that as well?
Voluntary work is absolutely fine. You can do that. The only rule that we have so far in the guidance is that you cannot work for your employer. Now, most individuals' contracts of employment probably have a clause that says you can't work for somebody else while you're under contract to your employer. So if you were going to try to work for somebody else, you would need to make sure that your employer either consented to that, or there wasn't a clause in your contract that prohibited it. But so far, the guidance doesn't say that you can't pick up work from a different employer. So that's a possibility.
Okay, and there's another one from Laura Hayes saying she's a director of a limited business and takes a dividend. Can she go into furlough employment along with the other employees?
Directors are employees, so on that sense, yes, directors can be furloughed as well, as long as they're not working. And that's absolutely critical. If you're doing any work for the company, you can't be furloughed. And I think most directors probably will continue to work. The other point to make is that dividends are paid to shareholders, so they're not part of your salary. So I doubt that dividends would be covered under the grant scheme. So whatever you took as salary is probably the maximum that you would be entitled to recover the 80% of. But really important that you don't work while you're on the furlough scheme.
Okay, I just want to hand it over to any of the panelists. There's a few other questions there. Does anybody want to take one or two of those, or we can close the call in the next 5 minutes? I think everybody's very patient, and I don't want to go on much further.
Jude, I could probably pick up two of the questions that were asked.
Okay.
One of the participants had asked what the legislation had referred to. It is on the slide, but the specific legislation I was talking about are the regulations that were made at the Scottish Parliament yesterday, the Health Protection Coronavirus Restrictions Scotland Regulations 2020, which should be available by now online, and those were the regulations I was referring to when I was talking about premises that remain open but ensure social distancing, such as the 2 metres and so on. There was also a second question from Paul about can he go into work in order to pick up work to take home. That might depend on your employer's policy. So, for example, we are not to enter the office unless I suppose it's an emergency or it's exceptional. In terms of the regulations, you're basically not to leave your house except for exercise or for shopping or for medical reasons, but there is a carve-out that says if you need to travel into work in order to do work that you couldn't otherwise do at home. So subject to anything Police Scotland might say to the contrary, I would have thought that a degree of flexibility might be offered if in the next week or so people were attempting to kit themselves up for home working from supplies that were otherwise in the office.
Okay, anybody else got any of the other questions they want to cover? I think there was a theme to most of them anyhow, so I think it was all around furlough and the legal implications and stuff as well. We'll close off the call. People have asked for a calendar of a series of webinars. I'm reluctant to send out a calendar because things are changing and information is coming at different rates. So what we're trying to do, myself and Paul and a few others, is decide probably on a daily basis as to when we do the webinars. So next week we're going to do Tuesday and Thursday, and if there's sub sessions that we think that maybe that somebody else from the speakers have covered something and there's an update in the law or there's an update in some of the stuff around funding and everything, we will basically send out to everybody that's been on these sessions an update webinar just for people to jump on even for half an hour to get an update on what's going on. There's also, I want people then as well to go away and think about the good things that are coming out of this as well, because we've been talking to so many different businesses that have really turned things around and thinking outside the box, and also particularly around furlough, that we had a conversation with Simone at Taranata yesterday about that she basically managed a lot of volunteers for the Commonwealth Games. And she's looking to try and do something and use her skills, even though she's working 12 hours a day at her own job, to basically build something for the NHS and Scottish Government and Police Scotland and stuff. Can we take that kind of pressure off our services as well when they're trying so hard to do this as well as their day job as well, and use our skills. Also, my previous role is around data science, and what I can see is a huge shift in how, organizations like the Land Registry and stuff like that we were speaking to before about getting more digital savvy, getting things online and stuff. It wasn't happening. So what kind of we are going to have a really digital savvy or state of the nation whenever we're finished with this, and hopefully things online. But the other thing, the worry about that is around cyber crime. So next Thursday we're going to do something on the cyber crime as well, to make sure that when you're working from home you're protected. What Kieran Martin, the CEO for NCSC in London, is going to take part as well, and basically share on the findings, what they're finding around the cybercrime stuff. So even there's yesterday's hoax was text messages coming out from UK government to say that you'd got out of your house 3 times and you had to pay a fine. So I stood outside my house 4 times, so I owe UK government quite a lot of money as of yesterday. So things like that there will be people that maybe did do things like that, or they've been using data on Strava. We don't know what so the good people get better at times like this, but the bad people get bolder. So everybody watch out for cyber stuff and keep your eye on how you're running your company as well, technically. Paul, do you have any last minute things? Are you still there?
Yeah, still here. First of all, thanks to all the panelists. I think it was a really insightful piece of work from you all, and I'm sure everybody on the call will find that tremendously useful. Lots of follow-ups from here, I'm sure, as there was earlier in the week. I think that's about all I've got to say. Jude, great job again. And don't forget, everybody that's on the call, to go to the Scottish Business Resilience Centre LinkedIn page. The session has been recorded. Please distribute it to all your friends in business or your colleagues. Make sure everyone's aware of it. The wider we can get the message out, the better. Hashtag here to help.
Thanks, Paul, for doing my marketing for me. Okay, everybody, we will finish the session now. Thank you very much for joining us and staying with us. Thank you.
Thanks.